Welcome back to Counterpoint. We're unpacking the recent federal justice court ruling suggesting that or declaring rather, that the Emergencies Act was actually should not have been invoked, that it was not appropriate. And joining me now is Joanna Baron from the Canadian Constitutional Foundation and John Carpay from the Justice Centre for Constitutional Freedoms. Joanna, before commercial break, we're going through some of the other points that one has to meet and criterias and impacts even of the Emergencies Act. Speak to us about freedom of speech and even freedom of assembly vis-a-vis this decision by the justice.
Yeah, so Justice Mosley found there was a violation of freedom of speech. He did not find in the result that there was a violation of freedom of assembly, although the CCF is cross appealing on that point. But let's talk about freedom of speech. Justice Mosley found that because a peaceful protester who went to the Ottawa protest or any other protest, in protest of the mandates and everything else that inspired the Freedom Convoy, if they were just peacefully protesting with a placard, nothing to do with a truck, certainly no suggestion of any other ill intent, that conduct would be caught and would be unlawful under the, expanded police powers that were delegated
Mhm.
by the invocation of the Emergencies Act. And that's just on its face a clear violation of the right to expressive political activity. That's at the core of the guarantee of Section 2B.
Now, John, why don't you talk to us about the search and seizure component of the Emergencies Act and what Justice Rouleau felt to that point?
Well, this was extremely important that there be a court ruling that this was illegal, unconstitutional, unjustified violation of charter rights and freedoms. That we would have a government so quickly, so arbitrarily freeze bank accounts of people without any due process. The people that were locked out of their bank accounts did not have an opportunity to defend themselves legally, to put forward their case, to protect themselves. There was no court order, court approval, court authorization. It was just this blanket kind of, from the lips of the prime minister to the to the people running the banks, without this is just a total breakdown of the rule of law. And so it was really valuable, really important to have a federal court declare this was an unjustified violation of the charter right to be free from unreasonable search and seizure. The economic damage this has done to Canada is almost incalculable. People don't understand. I mean, this hurts our reputation internationally. It makes us less favorable for investors when you behave like a banana republic or some
Hmm.
repressive regime. So it was just refreshing as well to have a judge that would look at the facts, look at the evidence, and even though it was obvious from the ruling that this judge did not like the truckers, did not agree with their cause, the judge partially bought into the Trudeau narrative that these were, probably dangerous, violent, neo-Nazi, racist criminals. You can see the judge doesn't like the peaceful protesters. However, he still goes ahead and rules against what the federal government did. So that's very positive.
Now, it was interesting following the release of the decision, Deputy Prime Minister Chrystia Freeland, she reiterates the government's stance that economic threats can constitute a threat of security of Canada. Like that was her big plank. Joanna, can you speak to that and explain? Well, I guess I was a little shocked that she would double down on that after this decision, but explain what she means by that and what is your response to it?
I think this was something that you saw throughout the Rouleau Commission, her in her evidence, and while she was cross-examined, that she kept coming back. She would not deny the fact that economic harm is not contemplated within the Emergencies Act. The Emergencies Act, we know, because we have the debates, it wasn't that long ago that it was adopted, that they were talking about physical violence and threats to persons and property. She kept coming back to the fact that no, disruption and inconvenience and the fact that the Rideau Center was shut down and missing out on millions of dollars of trade and whatever you think about that the decision that we made collectively as a country was that that type of conduct should not be dealt with by emergency powers. And in fact, it seems likely that the government is going to propose amending the Emergencies Act to encompass economic harm. And I really think people who believe in the rule of law and liberty should reject any such amendment.
John, we have about 30 seconds to commercial. Do you have any further comments on Chrystia Freeland's response there?
It's sad that she seems to want to lower the bar and make it easy for the government to declare a national emergency. The way that the Emergencies Act is structured is that it has a very high threshold. So you need that, threat to national security, threat to sovereignty, threat of serious harm to people, etc. You need this very high threshold, and that no other laws are available.